X man offered to purchase real property. However, X died of a heart attack before the listing broker could notify him of an unqualified signed acceptance by the seller. Based on these facts, which of the following is true? Is it the death of X constituted a revocation of the offer? Is it the offer and acceptance constituted an enforceable contract? Is it notification to the administrator or executor would bind the estate? Or is it the sale would not be binding because the deed was not delivered before X's death? What do you guys think? So here's the thing. The death of X constituted a revocation of the offer. So here's what happened. Let's pretend X is me and Carolyn is the person receiving this offer. So I make an offer to Carolyn. However, before Carolyn responds and lets me know that she's accepted, I'm dead. I die of a heart attack, right? If that's the case, we didn't have that delivery and acceptance back, right? We had an acceptance, but we never had a communication of acceptance to the person who made the offer. So it would be just like if I wrote an offer to you and you signed it and stuck it in your desk drawer, it never let me know that you accepted it. And then you went off on vacation for a week. I don't know that you've accepted it. So we don't have a contract until you've communicated your acceptance back to me. So that's why this one is A. Yeah, if the seller passed away before they were notified of acceptance, either party, we got to have the accepting party, the person accepting the offer or accepting the contract, but they also have to communicate that acceptance back. Yep, exactly. What if he got an acceptance, then he died? Okay, tricky. Jane says, what if he died after the contracts came into play, right? They had notified them of acceptance and then he's dead. Now that's different because right now we don't have a binding contract because there was never that delivery of acceptance. But if we had a delivered contract that was binding them, and then after the contract came into play, someone died. In that case, the heirs could be responsible, depending on what the judge decided, for that contract. But here it never became a contract because the guy was dead before we ever had that acceptance, right? We never had that communication of acceptance. So this is a good brain twister, right? All right. So the primary purpose of a listing agreement is to what? Is it to serve as a guide for a sales contract, give the broker permission to sell all of his principal's properties, list all improvements and amenities to the property, or serve as a contract of employment between the broker and the owner? What do you guys think here? The primary purpose of a listing agreement. What do we think of primary purpose of a listing agreement? And right, everybody got this one right out of the gate. It serves as a contract of employment between the owner and the broker. Remember, who owns the listings? The broker. He's the owner of the listings and for the office. And so that contract is an employment agreement between them. Anytime we have an employment agreement, that's a listing contract. What about if I had a buyer agency agreement? A buyer agency agreement is another one where it's an employment contract between the broker and the buyer. The buyer has agreed to work with that brokerage and pay them a commission if they get the job done. So this is the contract between the owner and the broker. Okay. A contract in which all parties have fulfilled their promises is it an executory contract, completed contract, executed contract, or an expired contract? A contract in which all parties have fulfilled their promises. Executory contract, completed contract, executed contract, or expired. Yeah, this is executed. When something is executed, we kill it, right? We get it completely done. An executed contract. Now, what would be an example of an executory contract? What's something that we could still be working on in an executory contract? An executory contract also could have, I'm thinking of a contingency. If I had a contingency in a contract for inspections, for example, maybe I want a contingency in my contract for a termite inspection. In that case, until the termite inspection is done and clear, the contract is still contingent upon that. We wouldn't have it closed until that's over with. Also, financing. If my contract is contingent upon financing, and I'm still working through the terms of the financing and the contract, then that would be executory. Until we get everything resolved, then we have an executory contract. But once all the contingencies have been met, everything's said and done, then we have an executed contract. Okay. There is a written agreement in which an owner allows an individual to use a property in exchange for rent and also gives that individual the right to buy the property for a specified price within a specified period. This contract would most likely be, is it a listing contract, an estate at sufferance, a lease option, or an estate for years? What is this called when I'm allowed to buy the property for a certain amount if I choose to during the lease? That's the lease option, right? So here are bonus points, you guys. Tell me if you want to real quickly. What is an example of a lease purchase? What is an example of a lease purchase? What's the difference between a lease purchase and a lease option? I guess is a better question. Yeah, in the lease purchase, we actually have a purchase contract at the end. Okay. In a lease purchase, we actually have a purchase contract at the end of the lease. But in a lease option, we have the option to buy for a certain amount of money. We don't have to, right? So in a lease purchase, we're for sure going to be selling the house at the end. In a lease option, they might or may not buy the house. Very good, guys. All of the following are essential elements of every valid contract, except, is it the payment of money, adequate capacity of the parties, a legal act, or a meeting of the minds? You guys saw that one. You guys, a lot of people caught this one. So they realize that it's not the payment of money, because listen, we have to have consideration in a contract, but does it have to be money? What if I offered you to give you 3 tractors in exchange for 2 acres of land? I don't know, I'm just making something up. That's not money, is it? But it's still a valuable consideration because I'm giving you something of value, the 3 tractors, in exchange for you giving me something of value, which is the land, right? So when we're talking about a valid contract, it doesn't necessarily have to be money. We have to have consideration. We have to have a meeting of the minds or mutual agreement. We have to have legal purpose, and we have to have competent parties. But notice that the consideration doesn't necessarily have to be money. It can be anything that we consider of value, right? All right. Good job, guys. Which of the following is not required for a contract to be legally binding? Which of the following is not required for a contract to be legally binding? Is it a proper writing, a lawful object, mutual consent, or capacity? So we just went over these, right? Consideration, meeting of the minds, mutual consent / meeting of the minds, competent parties, and legal purpose. But a proper writing isn't necessarily necessary. Isn't necessarily necessary always to have a legally binding contract, because some contracts don't have to be in writing to be enforceable, right? Some contracts don't have to be. So for example, if I made a contract with Jane to walk her dog every day for $10, I walk her dog every morning for $10 and we shake on it. We don't have to put that in writing in order for it to be a valid contract, because it's a pretty small potatoes things. So let me ask you guys real quickly. Here's another question I have for you. If we're talking about a contract that has to be in writing, like most real estate contracts do, what is the law that tells us that most real estate contracts, with the exception of some short-term leases that are less than a year or less, but what's the law that says that real estate contracts have to be in writing in order to be enforceable by a court? What's that law called? Yes, statute of frauds. Very good, you guys.